Welcome to today's webinar. We're going to get started in just a moment. We're just letting the last few people sign in. Okay, it looks like we have the majority of people signed in now. Thank you so much for joining us today for today's webinar. Today we're discussing the Human Rights Code of British Columbia, and specifically the landlords and their duty to accommodate. And I'm not going to be presenting this one. We have Laura Track from the Human Rights Clinic. She is Director of Education and a lawyer at the Human Rights Clinic. She's going to join us in just a few moments to present on this. Before we get into the webinar itself and the content, just a few little housekeeping things. So throughout the webinar, if you have a question, go ahead and ask it. We will get to the questions at the end of the webinar. You'll notice at the bottom of the screen, you should see a little Q&A button, which should pop up a dialog box where you can put your question in. And like I said, we'll get to those at the end of the presentation. If you're not already a member of LandlordBC, definitely reach out to our Director of Member Engagement, Kimberly Coates, to talk about membership options. She can be reached at 1-855-707-2366, or just email her at kimberlyc@landlordbc.ca. I'd like to just do a special thank you to today's sponsor, BFL Canada. They were founded in Montreal in 1987 by Barry Lorenzetti. BFL Canada is one of the largest employee-owned and operated risk management, insurance brokerage, and employee benefits consulting services firm in Canada. They have a team of over 850 professionals located in 19 offices across the country. BFL understands that each entity is unique due to a variety of factors, and their real estate professionals are dedicated to delivering coverage solutions that fit your needs. However simple or complex the insurance or risk management needs may be, BFL is there. BFL is proud to partner with an organization like LandlordBC and to be a sponsor of today's webinar. Thank you to BFL for sponsoring today's webinar. So I'm going to go ahead and bring on Laura. So Laura, I see that you've signed in. You can go ahead and join us, and I will stop sharing my screen and you can start sharing yours.
That sounds great. Thank you very much, Hunter. And thank you so much to LandlordBC for hosting me today. It's a pleasure to be with you. I'm not able to share my video, but I should be able, oh, nope. And Hunter, I'm not able to share my screen either. It says the host has disabled participant screen sharing, and the host has stopped video. So maybe I'll just pause for a second and see if that can be adjusted. Oh, here we go. I think we are good.
Perfect.
Great. Okay, so you should be able to see my screen now. You don't really need to see my face, I don't suppose.
I'll get your video working as well.
Oh yeah, okay.
Yeah.
Well, while that is happening, I will just tell you a little bit about the presentation and about myself. So as Hunter said, I'm a lawyer and the Director of Education at BC's Human Rights Clinic, which is a program of the Community Legal Assistance Society, or CLASS for short. And a little about the Human Rights Clinic. We provide free legal services to people who need help with a human rights complaint here in BC. We're a province-wide organization, though we are based in downtown Vancouver. And we provide a range of services, including staffing a telephone line that's available 9 to 5, Monday to Friday, where people can get information about human rights in BC and about the process for making a human rights complaint. We run what's called a short service clinic every Monday, where folks can make a half-an-hour appointment with a legal advocate or a lawyer to obtain more specific information and advice about a problem that they might be experiencing. And then when people have made a complaint to the Human Rights Tribunal about an allegation of discrimination, they can apply for representation from our clinic. And we do our very best to match people up with a lawyer or an advocate who can assist them with their complaint. Our services are specifically for people who have made complaints under the Human Rights Code rather than parties that we would call respondents who've had complaints made against them. I'll just note that there is a free service geared more towards respondents operated out of the UVic Law Center, and respondents can obtain free legal support through that organization. The other service that we provide are education workshops. So it's a real treat to get to be with a group like yours. And thanks again to LandlordBC for having me. I love to come and present information about the Human Rights Code and help people understand their responsibilities and obligations under the code. Looks like, oh, there we go. Hello.
Oh, perfect.
Cool.
So
nice to be able to see you.
I'm going to back out then and let you go ahead. So thank you again so much for joining us today, Laura. And as I mentioned before to our attendees, if you have questions, please go ahead and put them in the Q&A box throughout the webinar as you think of them, and we'll get to them at the end.
That's great. And I'm going to set a timer for myself so that I can do my best to leave time for questions at the end. So that's a bit about us and a bit about our services. And as you know, our topic for today is how the Human Rights Code intersects with the services that you provide as landlords providing housing for tenants in BC. So the BC Human Rights Code covers landlord-tenant relationships and protects tenants from discrimination in the context of their housing relationship with their landlord. The Human Rights Code also covers stratas and people living in stratas under a different section of the code. The code protects people from discrimination in the services that are provided by stratas and the strata councils that make decisions and set bylaws and so forth. Those things all have to be done in a non-discriminatory way. And I'm going to take you to the section of the Human Rights Code in a second that protects tenants from discrimination in BC, but I just wanted to start with these two quotes from Human Rights Tribunal decisions, pretty recent ones over the last couple of years, that remind us of the purpose of protecting tenants from discrimination through human rights legislation. I don't think I have to tell any of you that housing is a critical, fundamental human need. And folks in protected categories have faced exclusion from housing over a long time. There are groups that have been marginalized from the housing market who have struggled to find adequate, affordable, safe housing for many years. And it's important that we have laws that protect people from discrimination as they try to access such a fundamental human need, the second step in Maslow's hierarchy of needs, as the tribunal pointed out in the James and Silver Campsites decision. And just a note, I'm going to refer to a number of cases throughout today's workshop. I am happy to make these slides available to folks after the workshop so that you can look those cases up if you're interested in doing so, just so you understand what these sort of codes mean here. This is the name of the case, so these are the two parties who were involved in the case. It was the second decision in this case, and this is the year the case was decided. BCHRT stands for BC Human Rights Tribunal, and it was the 9th decision from the tribunal that year. And then sometimes there'll be a paragraph reference. If you're ever interested in looking up legal cases, there's a database called CANLI, C-A-N-L-I-I, where you can find all of these decisions if you just type in the name or that what we call the citation there, the 2018 BCHRT 9, you can pull up the decision and have a look at it for yourself. So this is the section of the code BC's Human Rights Code that protects people from discrimination in the context of their tenancy. So it refers to denying a person the right to occupy a space as a tenant. And then in B, it refers to discriminating against someone in the context of their tenancy. And then the smaller text below sets out what we call protected characteristics, also known as prohibited grounds of discrimination. So these are the aspects of our identity, our characteristics that are protected from discrimination by the code. And you can see the list there: race, color, ancestry, place of origin, referring to factors that often combine or overlap to make up someone's ethnic background, someone's religion, their marital status or family status can't be a cause for discriminatory treatment, physical or mental disability, as well as the perception of those things. I'll also note, and we'll talk about this perhaps a little bit later, addiction does constitute a physical disability for the purposes of the Human Rights Code. Discrimination on the basis of sex is prohibited. That would include things like sexual harassment, sexual orientation, gender identity or gender expression, age, and lawful source of income. These are all protected characteristics, aspects of a person's identity that can't be used to deny them a unit for rent, or that they can't be treated poorly on the basis of within the context of a given tenancy. There are some exceptions to the protections from discrimination in tenancy in the Human Rights Code. The first is in a situation involving shared sleeping, bathroom, or cooking facilities. Folks will be familiar with that exemption in the Residential Tenancy Act as well, although I'll note that in the Human Rights Code, the exception applies when the tenant or prospective tenant is going to be sharing sleeping, bathroom, or cooking facilities with the person representing the unit as being available. So that might not necessarily be the owner, whereas my understanding is in the Residential Tenancy Act, the sharing has to be with the owner to be exempt. In any event, shared sleeping, bathroom, and cooking facilities, situations like that are exempt from the code. It's also permissible to have housing that is designated for those aged 55 and older. So a person under the age of 55 couldn't make a complaint about discrimination on the basis of age or perhaps on the basis of family status if they have kids. Those kinds of units for older folks are permitted. It's also permitted to have housing specifically designated for people with disabilities. There's also a section in the code that says that nonprofit organizations that are serving a particular population are allowed to take steps or make decisions to favor or prioritize that population that they're serving. So nonprofits may, in some situations, be exempt from the code when they're working to advance the interests of a particular group that they exist to serve. This slide lays out the two parts of a human rights complaint and the two parts of the analysis that the Human Rights Tribunal would apply in making a decision about whether discrimination or discriminatory treatment has occurred. So the complainant bears the burden of proof for their side of the case. They have to prove that they have one or more of those protected characteristics that we saw set out in Section 10. They have a disability. They have a particular religion that's protected by the code. Usually that's not in dispute. That's generally fairly easy for a complainant to prove that they have the protected characteristic. And then they have to prove that they experience some kind of negative treatment or a negative impact in the context of their tenancy. And again, that's usually not so much in dispute. It's usually fairly straightforward to prove that you were evicted or otherwise experienced negative treatment. You didn't get the unit that you were applying for. What's hardest in most cases for a complainant to prove is the connection between those two things, proving the connection between the protected characteristic and the denial of the unit or the eviction or whatever the alleged negative treatment is. That can be more challenging. A complainant is going to have to bring forward evidence to support a connection between those two things, that their disability was a factor in why they didn't get the unit, or their sexual orientation was at least part of the reason. Doesn't have to be the only reason, but does have to be part of the reason why they got evicted, for example. If the complainant can prove those three things, there was a connection between a protected characteristic and some kind of negative treatment, then what happens is we say the burden shifts to the respondent to justify the treatment and to explain to the tribunal that there was some reasonable explanation and that the person cannot be accommodated in their tenancy without an undue hardship for the landlord, for the respondent. If the respondent can justify their treatment of the complainant and explain why there's a good reason for why the complainant was treated as they were, then there's no discrimination and the complaint is unsuccessful. But if the respondent cannot justify their treatment, and in particular what we'll talk about in a moment is if they cannot prove that they have accommodated the complainant to the point of undue hardship, then the complaint will be successful. Discrimination will be proved, and the tribunal can order a remedy for the discrimination. Common remedies that we see in tenancy cases at the Human Rights Tribunal are set out on this slide. Compensation for injury to dignity, feelings, and self-respect is awarded in just about every successful discrimination case at the Human Rights Tribunal because that's the intention of making a complaint, is to hold a respondent accountable and be compensated for the impact that the discrimination had on the person. So those awards are very common. We also often see the tribunal order the respondent to pay the complainant for expenses that the complainant incurred due to the discrimination. So in the tenancy context, that might include things like moving costs. If the tribunal finds that a person was evicted for a discriminatory reason and they had to move, they might have incurred some costs associated with that move that the tribunal may order the landlord to repay. The tribunal has also ordered landlords to pay a former tenant the difference in rent between the tenancy that they were evicted from and the tenancy that they moved into after the discriminatory eviction. So there may be an order, not forever, but for a limited period of time. I've seen a recent case where the order was for 12 months, another case where the order was for 6 months, where the tribunal says, but for the discrimination, the person would have only been paying this much rent. Because of the discrimination, they had to pay more, so the discriminator is liable for the difference. The tribunal might also order compensation for the cost the complainant had to spend to attend the hearing. And sometimes if expert reports are necessary to prove the discrimination, a respondent might be on the hook for those costs as well. The tribunal can also order more kind of systemic remedies. Compensation for expenses and injury to dignity is a more individual remedy, but a systemic remedy might look like an order that a landlord provide needed accommodations, building a ramp or installing accessible doors in the building, for example, might be something that the tribunal would order at the end of a successful discrimination complaint. This doesn't happen too often, but I am aware of a couple cases where the tribunal ordered a landlord to offer the unit to the person that they had discriminated against. The case I am thinking about involved someone who was discriminated against on the basis of their source of income. When the landlord found out that they received income assistance, they reneged on their offer to rent the unit to that person. And the tribunal said, if and when a unit becomes available, you have to offer it to that person, and they can then decide whether they want to move in or not. So that's also a possible remedy that the tribunal might order. What I thought I would do over the next, we have about 20 minutes before I want to shift into Q&A mode, 20 or 25 minutes, is go through what I think are the top 5 human rights issues that landlords are facing or may face. And I base this on my read of the case law and the experience that I have working at the Human Rights Clinic and assisting people who have human rights issues or who are alleging discrimination in the context of their tenancies. You might look at this and say, these aren't my issues at all. And so we can talk in the Q&A about other human rights issues that you may be seeing in the context of the work that you are doing. But these are the top 5 that I've picked out that I'm going to spend some time talking about over the next few minutes. Accommodating tenants with mobility limitations and other disabilities, addressing discriminatory treatment coming not from landlords, but from other tenants and what a landlord's obligation is in those circumstances, discrimination on the basis of family status and family size, source of income discrimination, which I actually just mentioned a moment ago, and the issue of support animals. So that's my plan. And number 1, accommodating tenants with mobility limitations. So Biggins was a case from just a couple of years ago, decided in 2018, as you can see from the case citation there. And it involved a woman. The OBO means brought on behalf of. So Ms. Walsh was the tenant with the disability, and the complaint was brought on her behalf by her partner, whose last name was Biggins. And Ms. Walsh has ALS. She has very serious disability and very significant mobility limitations. And her apartment had stairs up to the front door and no ramp. She and her partner had been asking for the installation of a ramp for quite some time, and the landlord had not taken steps to put that ramp in. So the tribunal heard all of the evidence, including evidence from experts about the logistics of installing a ramp. The landlord was trying to argue that it would be too difficult, they could never get permits for it, and was of course arguing also that it would be very expensive to install the ramp. And what the tribunal confirmed for us in this case is that where a physical barrier, like stairs, prevents a person with a disability from accessing their rental unit safely and with dignity, the duty to accommodate requires that the housing provider take all reasonable and practical steps to remove that barrier. So I've bolded a couple of important terms from that sentence. Accessing one's home safely and with dignity really goes back to those sort of fundamental purposes of the Human Rights Code and the protections that it grants in tenancy. It's important that people be able to access their homes safely and with dignity. And when people can't do that, there is an obligation on landlords to accommodate them to the point of undue hardship. So taking all reasonable and practical steps is what is required. And that term undue hardship is significant. That is the threshold. That is the standard that a landlord has to meet. They may have to incur some hardship in providing the necessary accommodations. There may be some cost associated with providing the needed accommodations. There may be some inconvenience in having to provide needed accommodations. And those may be hardships for a landlord. Of course they are. But some hardship is necessary in order to ensure that to the greatest extent possible, barriers to accessing such a fundamental human need as housing are removed. And so in this case, the tribunal ordered the landlord to pay to the complainant $35,000 in injury to dignity, which was the highest award we've ever seen in the tenancy context. They also ordered the landlord to repay the complainant for the cost they had paid to get an expert to assess the building and the logistics of building the ramp and provide their report to the Human Rights Tribunal. And the tribunal lastly ordered the landlord to make all reasonable efforts to build the ramp. So something that in this case, the landlord should have been doing years before the complaint went to the Human Rights Tribunal, they now have to do anyway, as well as all of the time and expense that they spent to go through the human rights complaint process, plus the $35,000 in injury to dignity that they owe to the complainant. So taking reasonable and practical steps early to do what is possible to remove barriers that tenants with disabilities are experiencing in accessing their building is a wise business step. In addition to the importance of the human rights and dignity of your tenants, you will also potentially avoid a very costly human rights complaint. I also wanted to point you to the Vick and Finnemore decision from 2018, which reminds us that a landlord's duty to accommodate is focused on the specific housing that they provide to a specific tenant. Ms. Vick moved into a sort of basement suite type arrangement in the Finnemore's home, and developed a disability later on, quite a serious mobility limitation. Ms. Finnemore had intended this to be a temporary situation, temporary tenancy situation. And when she wanted the unit back for a variety of different reasons, she went to evict Ms. Vick, who made a human rights complaint saying, "I've developed this disability. Looking for new housing is completely untenable." She reported like falling on the bus and really struggling to find a new place to live because of the disability that she had developed. The Human Rights Tribunal in this case said no. A landlord does not have a freestanding duty to accommodate a tenant who has a disability and is facing barriers to finding new housing. The duty to accommodate relates to removing barriers to accessing that particular tenancy. And there was no evidence that Ms. Finnemore was doing anything to fail to remove barriers for Ms. Vick in her own home. The difficulties Ms. Vick was having was in finding new housing. And while the tribunal certainly sympathized with that struggle, I'm sure we all can sympathize with the struggle of finding housing in a difficult, very tight rental market that we have here in the Lower Mainland and in many other parts of BC. But a landlord's duty is not to remove, all barriers that a person is experiencing in the context of housing, but rather to ensure that the housing that they are providing is meaningfully accessible. Also on the topic of accommodating tenants with mobility limitations and other disabilities, the duty to accommodate, ultimately does rest with the landlord or with the respondent in a given case. They are the ones who have that obligation to take steps to explore reasonable accommodations and provide what they can without undue hardship. But it is also kind of a two-way street. And the tribunal has said on many occasions that the duty to accommodate is what they call a multi-party endeavor. So everybody has to be involved, including the complainant, including the tenant in this context. So a tenant has an obligation to participate in the process and to provide necessary information in order to allow the respondent to accommodate them. And also, and this is an important thing for complainants to know, they have to accept a reasonable solution. A complainant, a tenant in the context that we're talking about can't expect perfection. They can't insist on perfection. And if they reject a reasonable proposal, if the landlord has offered an accommodation that would meet their disability-related needs and would be reasonable in the circumstances, and the tenant rejects it, the landlord is likely going to be found to have met their duty to accommodate. And in this case of Burke and Mole Hill, Mr. Burke was looking to be moved into a different unit in the suite, but had rejected quite a lot of different units that had been offered over the years. And so when he made his human rights complaint, the tribunal dismissed it without a hearing. I should mention that the tribunal has the power to dismiss cases that have no reasonable chance of success without them having to go all the way to a hearing. And in this case, that's exactly what they did. The landlord applied to dismiss the case on the basis that they had tried to accommodate Mr. Burke, but he had rejected the options that they had presented. And in the circumstances here, the tribunal said, he's not participating reasonably. He hasn't considered the options that have been offered. It doesn't make sense for this case to go to a hearing. And so it was dismissed. Number one is a really big issue. We could spend a lot more time actually talking about the duty to accommodate tenants with mobility limitations, but I'll pause that topic there and move to topic number two, which is addressing discriminatory treatment by other tenants. So this is a tricky issue, but a landlord does have an obligation under human rights law to do everything in its power to provide a discrimination-free environment. In the same way that an employer has an obligation to ensure that the workplace is free from discrimination and discriminatory harassment, a landlord has a similar kind of obligation. Now, of course, a landlord can't be in all places at all times and can't prevent neighbors from engaging in discriminatory treatment of other neighbors. Unfortunately, we know that sometimes neighbors can be nasty to one another and may discriminate against one another, may harass one another on the basis of one or more of those protected characteristics that we looked at in section 10. A landlord is not going to be liable for the behavior of their other tenants. But a tenant who reports to their landlord that they are being discriminated against by another tenant, they're being subject to homophobic bullying or harassment, they're being subject to racist abuse by another tenant, by their neighbor. A landlord has an obligation to do something about it, to respond, to address the situation and do what they can to take effective action to protect that tenant from the discrimination they're experiencing, potentially up to and including evicting the harassing tenant. Maybe not as the very first option, but it could come to that. And so these are a couple of cases here on the slide where the tribunal has set out how it's going to approach these kinds of cases. A landlord will need to take action and respond to a complaint. But as the tribunal found in the Dawson case, there will be no liability where the landlord does respond in a responsible and prompt manner. So addressing the situation promptly and effectively, and letting the tenant who's alleged to be engaged in discriminatory harassment know that that won't be tolerated will go a long way to avoiding any potential liability on a landlord's part for discrimination. Number 3 of the top 5 human rights issues relates to family status. Family status was one of the protected characteristics that we saw set out in section 10. And family status has a few different meanings in human rights law. It might mean who is in your family. So it could be discrimination to refuse to rent to someone because you don't like their brother or their husband. Family status can refer to the kind of family that you are in. So for example, being in a single mother-led family, it would be discrimination to refuse to rent to someone because they're a single mom. Family status can also relate to family size and family composition. And I want to draw your attention to a couple of cases related to family size and family composition. The first is Abernathy and Stevenson, where a family of 6, 4 little kids, all under the age of 10, I believe, or maybe even a bit younger, had applied for a 3-bedroom rental unit, I believe in Victoria. And the landlord wrote back to Ms. Abernathy and said, 6 people is just way too many for this 3-bedroom suite. I don't want such a big family in this unit. And she wrote back and said, oh, but the kids are little. It's really easy for them to share a room. We're used to it. We're happy to squish in. And the landlord said, no, I don't. I'm not comfortable with that. This is a new unit, and I'm worried about the damage of having such a big family in it. No go. And Ms. Abernathy made a human rights complaint about that. And the complaint hasn't gone to a hearing. I should note that actually most cases in human rights don't go to hearings. They are either dismissed on applications to dismiss, which I was mentioning a moment ago, or even more commonly, they get resolved through a settlement. So I don't know what happened in this case, but I am guessing it has been resolved through a settlement because there was an application to dismiss that was refused. The tribunal said, I'm not going to dismiss this case on the basis that it shouldn't be heard. It should go to a hearing for us to look at all of the evidence and make a decision about whether the conduct was justified. But what the tribunal said in the application to dismiss decision was that you can't just rely on a maximum occupancy rule without justifying it, because that rule is going to create a disadvantage for people on the basis of their family status, and is going to potentially discriminate against people in larger families. So in order to justify a maximum occupancy rule or policy, a landlord would have to show that they have adopted that rule or that policy in good faith for legitimate reasons, perhaps related to maintenance and use, and that they cannot reasonably adjust that rule without it being an undue hardship. And in the Abernathy and Stevenson case, there just wasn't enough evidence that the rule was reasonably necessary and that it couldn't be modified without undue hardship for the landlord. Had it gone to a hearing, perhaps they would have been able to bring that evidence forward, but the tribunal said there's not enough to dismiss this in this preliminary way. In an older case called Chaw and Hollyburn Estates from 2005, the tribunal gave some guidance about what kinds of evidence might be relevant in order to justify a maximum occupancy rule. And they said things like, if there's not enough hot water to support that size of a family, or not enough parking spaces for so many people, or there's a municipal bylaw that sets restrictions, or some other legitimate health and safety consideration, that might be relevant to justifying a maximum occupancy rule. I also just wanted to put on the slide the Valdez and Bocelli decision from earlier this year. This was a case where the tenant was pregnant when she first moved into the unit. Apparently the landlord didn't know that. And when she gave birth, the landlord got very upset and angry and accused the tenant of being a liar, of misrepresenting herself, and made conditions so intolerable that the family moved out. The tribunal found that that was discrimination and ordered the landlord to compensate Ms. Valdez for the discrimination, as well as for moving expenses and the difference in rent between where she'd been living in the Bocelli's property and where they had to move. Lawful source of income is number 4 on our top 5 list. And you saw this in the list of protected characteristics in section 10 several slides ago. So it is discrimination to deny someone a unit, to evict someone, to otherwise treat them badly on the basis of their lawful source of income. So that word lawful is important. If someone is earning their income through criminal enterprise, it wouldn't be discrimination to evict them or refuse to rent to them. But if the source of their income is a legal source, then using that to deny them a unit or otherwise treat them treat them in a negative way, could well be discrimination. So most cases involving discrimination on the basis of lawful source of income relate to someone being on welfare, income assistance, or disability assistance. And the cases, and there aren't too many cases actually that make it all the way to a hearing on this basis, but most involve facts that the tenant applied for the unit, all was going well, they were about to move in, and then suddenly the landlord found out that a source of their income was social assistance and backed out of the rental agreement. I think, although I'm not aware of any cases, but I think like discrimination because someone's income comes from a pension, or even that it comes from a particular job, that could well be discrimination on the basis of a lawful source of income. It is just the source of the income that's protected from discrimination by the Human Rights Code. The code does not make it discrimination to deny someone an apartment, a unit, based on their amount of income, their level of income. It is justifiable and not discriminatory to make sure that someone can actually afford the unit that they are applying for. But if the discrimination relates to where that income comes from, that could well be contrary to the code. Number 5, support animals. I don't know if this is an issue that you're seeing much of, but we're seeing quite a lot of cases involving support animals. Most often, I'll be honest, arising in the strata context as opposed to a rental building, but the principles are the same. So what the tribunal has said in a number of cases is that a no pet rule may be discriminatory if a tenant is relying on that animal for a disability-related reason. At the bottom of this slide is a link to a blog post that I wrote that's available on our website that goes into quite a lot more detail about this issue, including with lots of links to a variety of case law. We have a number of blog posts on our website actually related to issues that may be of interest to landlords around the duty to accommodate tenants with disabilities and other related issues. Some of those have been published in the LandlordBC magazine, The Key, so you can find them either in your back issues of The Key, or you can go to our website and have a look at the blog and find what I hope will be some useful information. With respect to support animals, a couple important things to note. First, whether the dog is a certified guide or support dog is not the end of the story. The tribunal has said on a number of occasions that certification is not required, and what matters for the purposes of the human rights analysis is, does the person rely on this animal because of their disability, and would requiring them to no longer have the animal with them create a negative impact related to their disability. The essential question for a landlord to ask is, can the person and their animal be accommodated in the housing unit without an undue hardship, either for them as landlord or potentially for other tenants? Considerations of safety, if the dog is not well behaved, if it's lunging at children, these would be undue hardships quite potentially that would justify a landlord in refusing to allow the person to have the support animal. There have also been some cases where the tribunal said restricting the number of animals a tenant can have or the size of the animal might be justified, and the impact on others could all be undue hardships. However, in one case, the landlord tried to argue that, well, if I allow this one person to have a support animal, that's just going to open the floodgates to people having pets and calling them support animals. And the tribunal didn't have a lot of time for that opening the floodgates argument. It wasn't based on concrete evidence, and the facts of that case suggested that the person really did rely on their animal for a disability related reason and was entitled to be accommodated to the point of undue hardship. So that's my top 5. In just a couple of minutes, there were a couple of other sort of bits and bytes that I wanted to touch on before opening it up to questions. I want to note that the Human Rights Code protects people from retaliation for filing a complaint, or suggesting that they might file a complaint, or helping someone else file a complaint, or acting as a witness in a complaint. So really important to ensure that as landlords, you're not taking any steps to punish anyone for enforcing their human rights. Not that any of you would, of course, but just to note that it is contrary to the Human Rights Code. I also feel like there is often confusion about overlap between the Human Rights Tribunal and the Residential Tenancy Board or branch. And this can get a little bit complicated, but some of the basics to know are that they're 2 very separate administrative tribunals, and the Human Rights Tribunal does not and cannot enforce the Residential Tenancy Act, and the RTB cannot and does not enforce the Human Rights Code. So sometimes we see landlords arguing that a complaint shouldn't be allowed to proceed in the Human Rights Tribunal because it's already been dealt with by the RTB. And in most cases, that argument is not actually going to work because the RTB is not applying the Human Rights Code and not considering allegations of discrimination. That said, and this is where things can get a little bit complicated, if the RTB has made findings of fact or they have decided a particular issue, the same party may not be allowed to relitigate that same issue in the Human Rights Tribunal. And there's a case citation that goes into a little bit more detail about when that rule is going to be applied. This is my last slide before questions. This was just the last sort of odd and end that I wanted to touch on before opening it up. The Human Rights Code is what we call a quasi-constitutional law. So what that means is that other laws, rules, policies, and contracts have to align with the Human Rights Code, or they risk being unenforceable. The code has a section in it saying that it prevails over all other laws and policies. So the Human Rights Code is an important law and supersedes a rental contract. It would be a rental contract that violates the Human Rights Code, that doesn't align with its protections in some way, would be unenforceable, or at least that clause in the rental agreement could be unenforceable. So a clause that has an impact on a person in connection with a protected characteristics, like the no pet clause that we were just looking at a moment ago. That might be unenforceable if a person relies on an animal in connection with their disability. A clause that prohibits smoking in a unit, that could be unenforceable with respect to a person who, for example, relies on medical marijuana to deal with a disability that they may experience. Now, it's always going to be a balancing. Remember the 2 sides of the human rights analysis. If a landlord can justify the policy and show that it could not accommodate the tenant without an undue hardship, then they haven't discriminated, and the policy or the rule is fine. And so the medical marijuana example, perhaps that creates an undue hardship to be allowing a person to smoke in their unit. Maybe it impacts on other tenants or causes damage to the unit. And so what the tribunal would be looking for is, okay, well, have you accommodated to the point of undue hardship? What are the alternatives to this person smoking in their unit? Can they be permitted to smoke their medicine on the patio or in some other area of the grounds, for example? So the duty to accommodate and the duty to consider adjusting rules or policies really, I think, the takeaway that I'd want to leave you with is that it imposes an obligation to act reasonably, to do your best to investigate possible solutions and ways of removing barriers to people's access to the housing that they so desperately need. So with that, let's open it up to questions. And I've been seeing the numbers go up in the Q&A. Hunter, what do you suggest? Are you gonna
Yeah, so I'll
sort of,
go through and I'm
yeah,
going to ask these questions. So thank you so much, Laura, again for this presentation. It's incredibly informational and timely information as always. So again, thank you for that great presentation.
welcome.
We have had quite a few questions come in throughout this workshop. Thank you to our participants for your attentive for your attention during this time and for your thoughtful questions. Let's start here with something I think on the lines of the duty to accommodate, as we kind of focused on a few times throughout today's webinar, and really much of it does apply to that, really. The question is does the landlord incur 100% of the cost to install a ramp or walk-in bath, grab bars, etc., for the benefit of a single tenant, or can the landlord expect the tenant to contribute to the upgrades?
I would say that in most cases, it will be the respondent that has to incur the costs of ensuring that a unit is accessible, provided that they can do so without it being an undue hardship. And what the landlord's obligation is to provide what's reasonable in the circumstances. So that doesn't mean, you know, the fanciest ramp possible or the like state-of-the-art grab bars, but it does mean providing what's necessary in order to remove the disability-related barrier. I would think that if the tenant wanted something beyond the kind of reasonable basic model that would meet their needs, they could be called on to contribute to the cost of that fancier version. But the obligation for removing the disability related barrier is the respondent's. And I would just note that you know, millions of people in Canada live with disabilities. While it may be the one tenant that you have in front of you that you will be working with to accommodate, having an accessible unit available to rent to the many other people who have disabilities who may come along down the road. Our population is aging. Those adjustments that you make to your building are going to make your building more attractive to more people and are going to create advantage and access for folks that you maybe haven't even thought of yet. Parents with strollers, for example, older folks with walkers and canes who will appreciate the ramp up to the door. So I appreciate that it may feel like you're just providing accommodations for one person, but I think that those adjustments that you've made will ripple out even more broadly.
Well, and thank you. That's a really good point. I mean, we live in a very, you know, diverse province with people who have a diverse set of needs. So certainly, whenever you can set your unit aside in some way to kind of show that you offer something perhaps a little bit different, then that's great. And then it said, as you say, it's not just there for that single tenant. It can be there for future tenants as well. Something that might not have a direct answer, but kind of further to that is how much needs to be spent before you consider something to be undue hardship?
That is the $1 million question, isn't it? Sorry, that was a bad joke, but it really is the big question. Cost is almost always cited as the #1 concern when we start talking about the duty to accommodate. One thing that I'll say is that the Human Rights Tribunal and the courts that have considered these questions have really taken pains to remind us that while cost is important, we also need to make sure we're not undervaluing the importance of inclusion for people with disabilities. I think for a long time, it's safe to say that we have sort of undervalued the importance of creating inclusive spaces, not just in respect of housing, but in our workplaces, in our public built environment. The costs of adjusting those environments to ensure that they're accessible to all has not always been top of mind. So we have to make sure that we are thinking about the value of creating inclusive spaces. The answer to like, how much do you have to spend before it's an undue hardship is a typical lawyer answer. It depends. You have to spend to the point of undue hardship. You have to spend to the point of providing what is reasonable to the complainant to remove those disability-related barriers. And that's really going to depend on all of the circumstances. It's a very case-by-case assessment. And putting in a ramp, for example, pretty costly endeavor. That might be an undue hardship in a particular tenancy context. If that is going to bankrupt the landlord, that would likely be an undue hardship. But in many other contexts, it wouldn't be an undue hardship. And I should also add that the tribunal is going to be interested in what investigation was done into the cost and into the respondent's capacity to pay for it. What alternative sources of funding might be available. All of that is going to be relevant to the determination of whether a given cost creates an undue hardship for a landlord. And I appreciate that that's a sort of unsatisfactory answer, but it really is the best answer that I can give in a context like this, because it is so case specific. And so my advice is, if you're grappling with a situation like this, it's probably time to get legal advice from someone who can look at your facts, the cost for you, given your economic situation, and help you determine if you've likely met the point of undue hardship.
Thank you. Yes, and well, we knew what we were getting into. When we brought this topic up, we know there's a lot of it depends in this topic, certainly, and we can understand and respect that, certainly. And as you mentioned, certainly, this is one of those topics where reaching out to a lawyer is, when you get to that point where you're trying to make that decision, you don't know what the right decision is, and you might be wanting to say no. You might have you don't know if it's legitimate or not. Definitely reaching out, and LandlordBC, of course, has partnerships for that. Is there a difference on what is required or expected in single-family homes versus multi-unit buildings, multifamily buildings?
Well, I think that would very much be part of the undue hardship analysis. My sense, and I appreciate that not every landlord of a multi-unit building is super profitable in that, but my sense is that it's more likely that a landlord in that context will have resources at their disposal to provide for accommodations. Whereas a person renting out their own basement suite may have less in the way of resources to be able to take steps to remove disability-related barriers. So there's no hard and fast rule about any particular kind of tenancy context, but it would be one of the factors that would go into that case-by-case assessment of whether the landlord has shown that they have reached the point of undue hardship. And I'll just emphasize that accommodating does not have to be costly. Sometimes it is, but often there are many steps that can be taken that will have minimal cost at all. And because the goal is reasonable accommodation, not perfect accommodation, there are often reasonable steps that can be taken with a minimum of undue hardship for the landlord.
Definitely. On the topic, again, still of duty to accommodate, as you mentioned earlier, this is a process that involves all parties. Everyone has to be involved. And in the early stages, in terms of having the tenant, in this case, part of this process, is there a requirement on them to provide some type of proof that this is a requirement, such as a ramp or a support animal or smoking in the unit, any of these things that fall under duty to accommodate?
Absolutely. That is a key part of the tenant's duty to participate in the accommodation process. It may well be incumbent on them to provide some information about their accommodation needs. Obviously, if someone uses a wheelchair, their disability is evident and their accommodation needs are evident. But if someone is claiming the need for a support animal, for example, a landlord, I think would be entitled to request some medical confirmation that that person does rely on the animal for a disability related reason. Certainly the tribunal is going to require that level of evidence if a complaint gets made. So a landlord can absolutely ask for the information that they need in order to assess the accommodation request and put the accommodations in place. Obviously, someone's medical information is very private, sensitive medical information. And so ensuring that you're only asking for what you legitimately need in order to make the accommodations and taking steps to maintain the privacy and confidentiality of that information will be really important. But yes, absolutely, a tenant will need to provide some evidence to support the accommodation requests that they're making.
Okay, thank you. So now a question on discrimination. And it's one that does come up fairly often for us here at the LandlordBC helpline. If you have a situation, a special circumstance where you've allowed a tenant to have a pet, and specifically we're talking about a pet, not a support animal, not a certified guide dog or service animal, but specifically a pet, and it's a special circumstance. The tenant is looking after the pet because the previous owner had passed away and it was a family member, something like that. So they've inherited a cat. Is it discrimination to not permit, say, their neighbor, another tenant in the building, to do the same thing?
I'm going to bring section 10 back up because this is what the Human Rights Code says is discrimination, contrary to the Human Rights Code. And it can be tricky when we use the term discrimination because we have a sort of everyday meaning for that term to mean like treating people differently. So in the kind of everyday usage way of talking about discrimination, sure, I suppose it is discrimination to have one practice for one tenant and one practice for another tenant. However, to be discrimination for the purposes of human rights law, someone has to remember step number 1 of the complainant's case. They have to show that they have one or more of these protected characteristics, and that the landlord is treating them differently, treating them badly on the basis of one of these protected characteristics. So wanting to have a pet is not set out here in the code. So I don't think in the circumstance that you've described, Hunter, somebody would be able to make a human rights complaint about discrimination because they're not asking to be accommodated with an animal for a reason related to a disability or their age or their sexual orientation. They just want to have a pet, and the Human Rights Code does not protect that as a human right.
Thank you. So a question again on going kind of back to duty to accommodation and changing things in a tenancy. So if you have a situation where you have allowed a tenant to do a specific thing, say smoke medicinal cannabis in their unit. They've come to you with a legitimate need. They have a prescription from a doctor. They have a medical condition that requires this as medicine. And you have felt at the time that it was reasonable to accommodate. But over time, you've started to receive complaints from neighbors. Are you able to renegotiate that accommodation? Or is it that once you've set that accommodation, it is set?
I would say the answer to that is yes. You can always renegotiate or reopen the conversation. Accommodation is rarely a one and done situation. It's an ongoing process. And so if a situation changes and something that was agreed to as an accommodation has now become an undue hardship, it could certainly be renegotiated. And you might explore alternative solutions. You could continue to use your medical cannabis, but how about only at these times of the day, or so many times per day, or sometimes could you go outside, or, you would want to be exploring alternative solutions with the person. And I would imagine that the tenant would be, well, hopefully they would be open to having that conversation. But if they resisted having that conversation and insisted that, like, nope, this is my accommodation, they could well be at risk of being found not to have participated in the accommodation process, because, as I say, it is something that's ongoing and may have to be reinvestigated or re-explored, and including, in the other direction as well. An accommodation has been put in place, it's been working for a while, but the tenant's disability gets worse and they need to re-explore, reopen the accommodation conversation. It's always about keeping the lines of communication opening, and it's never a closed conversation, because situations change.
Right. Well, thank you so much. I know that there's quite a few questions that have come in, but we are now past one. I did not even realize that. So thank you for staying on a little longer, and thank you to our participants, to our attendees today, for your thoughtful questions. Certainly we'll be sending out some of this information in the email afterwards. Thank you again to our sponsor, BFL. Our sponsors are what make these webinars possible. So again, thank you to BFL for sponsoring today's webinar. And yeah, thank you so much. Stay tuned to our e-news for information about our next webinar next month. Thank you.
Thank you. Bye, everyone.